Court please, the sole issue in this case involves the sufficiency of the evidence with respect to the second clause of the resisting arrest statute.
Could I ask you a question? I know that that's what you argue, but I just – so you don't argue that that the defendant would understand that the police were seeking to arrest him?
I was about to, as I told Mr. Townsend, I will take off the table the fact that there was an arrest issue here. We concede, as the appeals court analysis did, that at least at that moment where the two officers had the defendant cornered under the staircase.
It could be a stop.
And well, they said, raise your hands or come out with your hands up. You're under arrest.
They said you're under arrest?
They said you're under arrest. I believe.
don't think so.
Or
at least I didn't find that in the appeals court decision anyway.
I thought they had said that at page 128.
Said that when they had them trained with their guns.
With their weapons drawn, confronted the defendant, ordered him to raise his arms and step away from his hiding spot or the stairs.
You conceded it. That's all right.
Well, I'm not disputing the analysis at that point. But then he fled. He fled. He crossed the parking lot. He jumped over the fence. And unbeknownst to him, there wasn't dry ground there. Instead, he fell 20 to 25 feet into this canal. Now, the issue that we're focused on is this, and compliments to the Commonwealth because the appeals court agreed that the mere act of jumping into the canal in and of itself created a risk of substantial harm to the officers. Now, we wholly disagree with that. The appeals court bought that argument. This was the argument that the Commonwealth raised at the motion for required finding at the end of the Commonwealth's case, again at the end of the entire case, and also in the renewed motion, 25B2 motion, by the defendant. Commonwealth made that argument that the act of jumping into the canal in and of itself created the risk of substantial harm. I mean, substantial harm, risk of substantial harm.
Is it risk of substantial harm or substantial risk?
Substantial risk of bodily injury.
Okay.
is the exact language.
Not only to the police officer, but to someone else.
But except in this case, the court looks at the instruction that the court gave. Mm-hmm. It was limited to harm to the police officer, and that's cited in our brief. Now, the court in the 25B2 motion said the word risk to me is it's an open-ended definition, and would permit a fact finder to find that the defendant's action, specifically jumping into the canal, could have created a risk of bodily injury. And that was why the court denied the motion. We, of course, take issue with, again, the Commonwealth's argument, which the court, again, the appeals court adopted, and that is, court said the fact that the officers chose not to scale the fence and jump 20 feet into the shallow water is not determinative of the question.
And then, as you point out in your supplemental brief, the cases on which the appeals court cited, the Pennsylvania case and the Alaska, well, just take the Pennsylvania case, there's very different facts. I'm wondering, are you aware of any cases where, with this sort of similar model penal code type language, where you have a situation like this where the risk is fairly theoretical, in that the officers didn't jump into the canal, if you see. In other words, there are cases, and I think Grandison is one of them, and the Pennsylvania case, where there was no actual injury, but arguably, I mean, there really was a risk because they could have slipped in the water, or they could have. This is different, and I'm wondering if you are aware of any cases like this one where the danger is sort of, if the officers had done X, they might have put themselves at risk, but they didn't do X.
Well, no, I think that the best case is the Alaska case, because the Alaska case says you can't base it on speculation or possibilities, that there has to be approximation. And I think Justice Ireland's decision in Grandison, although the appeals court cited Grandison in its decision, where this court emphasized the statute focuses on risk and concluded in Grandison that its elements were satisfied by conduct which could have caused the officers to be injured. Now, in Grandison, that was a situation where it took 4 officers to restrain and handcuff the defendant. And they said based on, his pulling away, the officers in that scuffle could have been injured. That's certainly quite different. And Lyons, even more so. Lyons, as the
Well, also in Grandison, the defendant bit one of the officers.
No, I don't believe so.
One
There was no
officer
biting
ended-
in Grandison.
One officer ended up on the floor and another managed to push the defendant into his cell, sustaining a bite in his arm in the process.
I apologize.
I mean, no, but what I'm saying is that there was really
Right.
serious...
Right.
But you're not suggesting there has to be physical contact between the defendant and the police. There's other kinds of risks, of course.
That's right. And I think if you look at the Lyons case, the Pennsylvania case, even though I point out that the appeals court left out the fact that the defendant was struggling and kicking as these 4 officers were trying to apprehend him and drag him out, that one could say just the mere conditions of the stream in Lyons, the swift-moving current, frigid water, rocky bottom, uneven surface, the officers had fallen several times. That in and of itself, you could say, created a risk of injury, separate and apart from the struggling. I don't think that's why the appeals court left it out. But in this case, you've got a canal, a muddy
I'm just
canal.
wondering, so change of fact, the canal is swift-moving. So there's going to have to be a rescue here. There's going to have to be a rescue. The police can jump in and rescue him. They can call downriver and have somebody try to get in a boat and rescue him. Would that make a difference?
I think it's still too remote. If you're saying swift-moving and he was being swept down, he's endangering himself, I suppose.
And the police have got they can let him drown, I suppose, or they can effectuate an effort to apprehend him in the swift-moving water.
Well, then you have to look at what that effort is. Did any of the officers try to go in? I mean, in this case, they didn't even step over the fence. They weren't even standing on the precipice where they could have
But
slipped.
if there were a dam downstream, a swift current and a dam, and he was going to go over, he's going to go over a very dangerous part of the water, then do the police have a duty? I'm sure there'd be a civil suit against the police if they didn't go in and try to, save him then.
I disagree with Your Honor.
Mr. Avogado, let me try to understand your position and focus on the words of substantial risk of causing bodily injury. If the defendant flees and into some circumstances that are very risky, or that create a substantial risk of a bodily injury, if the officers perceive this substantial risk of bodily injury and say, let the guy go, is that resisting arrest? Or do they actually have to take some kind of a step into the substantial risk?
I think it's the latter. I mean, if they see that there's peril, they don't have to subject themselves to that peril. And I don't think that they can be civilly sued because they didn't try to effect the arrest. They're not responsible for endangering their lives. The scenario that Mr. Townsend points out in his brief, pursuing over rooftops where does one have to fall into the abyss or be struck by a locomotive? No, they can opt, as they did here, not to go into the canal. But that doesn't, just because there's potential danger that is very remote, doesn't constitute resisting arrest.
So you're saying that if the police officers indeed had jumped into the canal, he'd be resisting arrest?
No, I'm not saying that because I don't think that even if they had pursued him into this canal, based on the description of the canal, that would have imperiled them, that would have created a risk.
The jump 25 feet into a canal doesn't pose a risk of substantial bodily
Well, if they
Gone headlong in.
dove off of the embankment at 25 feet, I think it would be pure folly. But if they had slid down and then gone in and walked in,
What did he do? He jumped.
he, based on his testimony, he thought when he jumped over the fence that there was dry land. That was his testimony. And in fact, he just fell into this void and ended up in the water.
It's hard to see where the dry land is.
Excuse me?
Hard to see where the dry land... Is this the fence over which he jumped?
That's correct. But, you know, you're talking
There's no dry land that I can see.
it's
They
10:15 at night. And
Oh,
Okay, but let's,
so it's dark.
let's go to our classic police chase in the tenements, okay? The classic jumping over the tenements with the 48-year-old police officer huffing and puffing. You saying then that it's not resisting arrest unless the police officer huffing and puffing actually jumps? I mean, is it saying
That's right, because otherwise it's just pure flight. And
okay, but
case
doesn't-
law is clear that
okay,
flight alone is
Okay,
not
so you're
enough.
saying that when, if I'm fleeing that police officer and I jump over the tenement roof, it's affecting arrest only depending upon whether that police officer is fool enough to follow me.
Correct. So if he ran to the edge of the roof and said, "I'm not doing that," that's not resisting arrest.
Okay, but one could say that doesn't flight invite pursuit, and therefore the flight provides a risk of this officer
That
being
completely
daring?
changes the case law then, because when we talk about flight not being enough, in most cases, there is also pursuit. Here, there was pursuit to the fence, and then they stopped.
Aren't you also saying that because this canal was shallow, it was not a danger?
That's right.
But how is an officer to know whether it's shallow or deep? Would you say if this was a deep canal that there would be substantial risk of bodily injury?
No. To answer the first part of the question, the officers knew it wasn't deep because they ordered the defendant to raise his hand. So he stood up, and you could see, based on his own testimony, that the water came to his lower chest. And the description of the canal was that the canal was 3 to 4 feet deep, maybe slightly deeper. So they knew how deep.
Well, that assumes that the only danger comes from the water. What if there were broken bottles in there and all kinds of refuse that have been thrown into the canal?
There has to be more, a closer approximation. They have to then go into the canal and attempt an apprehension. And as a result thereof, we're endangered. And it has to be a substantial risk, not any risk.
So shallow canal, no substantial risk. Deep canal, maybe?
Not unless they went in. A deep canal in and of itself, without us. And I'm not saying that there has to be a struggle. The appeals court, in its decision, said, that the appeals court in Grant left open the question whether the circumstances of flight without other physical resistance can constitute a violation of the statute. Now, that's not really what the court said in Grant. They said there is uncertainty in the case law and commentary regarding the circumstances in which flight on foot may constitute resisting arrest. So Grant wasn't saying, can you have it without physical resistance? And I'm not saying that either. That you can, as the example in the Model Penal Code commentary says, a high-speed auto chase through a residential area can constitute or create a risk of substantial injury.
As I listen to you, I'm getting a sense that you're changing the words of the statute to a risk of substantial injury, and you just did it. As I read the statute, there is a 99, if there is a, and I'm putting in the numbers, if there is a 99.9% chance of getting a boo-boo, the terms of the statute are satisfied. That there is no requirement that there be a 50% chance of losing a leg. It is a high probability of some bodily injury.
Right, but preceding that, and you're right, Your Honor, but it's the substantial risk that I asked the court to focus on.
99% chance of pricking your finger on a rose bush as you go through the bushes.
You're saying the police officer has to put himself in a position where he faces a substantial risk, and you're saying in this case they didn't do that.
They didn't do that.
They stopped at the fence.
Precisely.
Yeah.
So that if thereafter, I agree with Your Honor, if thereafter any sort of injury, bodily injury occurs, then the statute is satisfied. So you're right, and I apologize if I misquoted the statute, because it does talk about creating a substantial risk, and in this case, we submit that it was far too remote. The statute, therefore, wasn't satisfied, and that this court should reverse the trial judge's finding of sufficient evidence with respect to the motion for required finding and reverse the conviction. Thank you.
Thank you, Mr. Obligado. Mr. Townsend?
Thank you. May it please the Court, Thomas Townsend for the Commonwealth. This Court has dealt with this portion of the statute before in the Grandison case.
Yeah, but isn't the problem here, Mr. Townsend, that what the Commonwealth is trying to do is to twist this statute to cover something that was never intended to cover? It was intended, as Justice Bartz had pointed out, to cover when the police are actually standing right next to the guy, and they're trying to arrest him, and he is physically resisting them, as in Grandison. And the problem, and that's why it says a substantial risk of physical injury, because that's what the legislators were envisioning. And I just think that it seems to me that by the words of the statute, you can tell that they weren't intending to encompass this type of situation, because then we get into these absolutely arcane discussions of whether the police officer has to jump into the water and how deep the water has to be and whether there's junk in the water. I mean, that wasn't what the statute was designed to cover, and it's because you're trying to enlarge it to encompass situations that it was never designed for that we're getting into these problems.
Well, I think the statute does cover the struggle-type scenarios, where the
When
defendant uses
they're
force.
next to each other and they're struggling, when the officer's putting the cuffs on and the guy is resisting arrest.
That's Lyons, right? Lyons, they're in the water.
Well, the statute clearly talks about physical force and any other means.
Right.
So the question is what any other means.
The first part of the statute tries to prevent the use of physical force, the use of violence, or the threat of force or violence. So there has to be that for the first part of the statute. The second part of the statute tried to prevent exposure to a risk of substantial risk of bodily injury. And the language, as the appeals court pointed out, comes from or is similar, almost exactly similar to the Model Penal Code, which has been passed in numerous jurisdictions.
But in this case, there is no risk. Mr. Abogado is saying they stopped. They saw the curtain beyond which the risk, there was a substantial risk, and they said, not today.
Well, the risk was still there. They were in full flight chasing the defendant. They were 10 yards behind the defendant. He goes over into the water. They stop. The risk was still there. They were exposed to that risk. And as the comments in the Model Penal Code said, flight from police can constitute resistant arrest if the circumstances of that flight exposes the officers
Yes,
to a
but don't you
significant
think the
risk.
example the Model Penal Code gave, which is the driving through the residential area, I mean, they really are exposed in the sense that they are driving. It's not like they're stopping at the gas station on the corner saying, geez, if we went fast through there, we would be at risk. So therefore, I mean, that seems to be the analogous. If they stopped and didn't drive, but they didn't jump here. They didn't go over that fence.
Because they were able to stop in time. If
They could stop and that's why I asked in the earlier argument about whether just the weaving through at 40 to 50 miles an hour, I know we don't know, but I assume by focusing on 40 to 50 miles an hour, it was not on a highway. I may be wrong. But it seemed to me that, I mean, because of the Model Penal Code and other things, I mean, we know, just as a matter of fact, that often causes people to get very seriously injured.
correct, and the statute just not only protects the police officers, but it protects anyone else who may be in harm's way. And that's the key, in harm's way. The officer here was in harm's way.
No, he wasn't. When he stopped at the fence, he wasn't.
He managed to stop. If the
No, he
defendant,
managed to stop. He stopped. He's running, you can stop. I mean,
Right,
it's
but
not as if he's running downhill or he's on skis and he can't stop. If you stop, you stop. In exactly the same way the police officer might reasonably say, I'm not going to go on a high-speed chase because even if I know how to drive in those circumstances, there's a risk of injury to all kinds of other people, including the person I'm chasing.
well, the statute's designed to protect, to prevent dangerous conduct and to enable the police to execute their duties.
What are
of
the
arrest.
what are the means? What are the means which are being used to create a substantial risk?
Means is the flight to the fence,
we know
over
that
the
if-
fence, and into the canal. That's the flight itself is the means. And as the appeals court said, means can be any method or course of action to achieve an end. The defense end here was to escape from the police and
But
destroy
we know
evidence.
flight alone is not enough, right? So
Flight alone is not enough. So if there was an open field, that would not be
what's your
enough.
best case? What's your best case for where there was some objective set of circumstance, but the police had stopped, didn't engage? They saw whether it was jumping off a roof or into a canal or chasing a car. What's your best case where the police withdrew from the substantial risk themselves? They stopped.
Well, there are very few cases dealing with this issue at all.
No, what's your best case for saying we should follow that? I mean, this is a statute that's all over the states, model penal code. Lots of times police stop chasing. We know that.
Well, the closest case, factually, is the Lyons case.
But
But
it's
of course,
not-
the police did go into the water. But I
They
think
went
if the
into
police
the
had
water
stopped
and
at the water,
he resisted arrest. So is there any case?
I do not know of any case.
Doesn't that tell us something?
But
No, because there are so few cases generally that
Are
get.
there many cases where the police officers stop? We have cases like that all of the time.
But the charging decision doesn't necessarily charge him with resisting arrest.
That's
If they're
Justice
charged,
Cowan's point.
well, it would be a different calculus if he had been charged in those cases with resisting arrest. Whether the elements were met in those circumstances would be consideration. But there are few cases dealing with this prong, the other means prong of the statute, even though numerous jurisdictions have the identical statute.
Can we go back to the reckless driving situation where the police are trying to effectuate an arrest and the individual jumps in a car and begins to zigzag through traffic at great peril to other people on the road? The police determine not to pursue.
Correct.
They call ahead and they try to get him interception because they don't want to pose the same peril to others. Wouldn't you agree with me that that's creating a substantial risk?
I think it is creating a substantial risk.
To
not
injury
only
to others? 'Cause it's
because the
not just
police,
the
even
police
though the
officers.
police backed off,
Right.
if they had continued, there'd be a substantial risk to them, but also the substantial risk in that scenario to other people.
But there's a crime there, a separate crime there. Isn't that failure to stop for a police officer? When you're driving a car and you fail to stop for a police officer, that is a crime.
And that protects the
And
police.
and that's a separate crime and
well,
that
it
is covered by
protects
another
the police
statute.
interest.
Driving to endanger. I mean, there's lots
Both,
of
I
things.
mean, both
Well, it
of
could
them,
be
but
a number of
specifically
crimes.
failure to stop.
If the elements are different, they can be convicted of both or all of them.
So you're saying that if you read, there is a way to read the statute. It says that if a person knowingly prevents an officer from effecting an arrest by creating a substantial risk of bodily harm to himself, to the officer or to others, it's the creation of the risk that prevents the officer from effecting the arrest.
The defendant's conduct and his intent is no different, depending on whether the officer actually confronts the danger or backs off from the danger. What we're trying to prevent are the dangerous scenarios that we can envision with multiple hypotheticals. A defendant darting across a 6-lane highway with cars whizzing by. If the police officer pulls up and the car just barely misses him, the defendant's conduct is no different. But he did expose the officer to risk. Bodily injury is not a requirement. It's the substantial risk of bodily injury that the legislature is trying to prevent.
So the officers don't have to, in your view, the officers do not have to accept the risk and pursue. It is enough that the risk was, in the words of the statute, created, and the officers turned away.
That's our position, and that's why I thought the appeals court quite eloquently put it. In Grandison, there was no bodily injury to the officer. Mr. Grandison pulled his arm back as they were trying to cuff him. He did not strike an officer, but that risk that he could have struck the officer was enough. The biting occurred later at the police station.
Yeah,
that
but-
was not the basis for the conviction. The conviction was ultimately overturned because it was unclear what conduct the Commonwealth was relying on. But the action itself of flailing the arm away and almost hitting an officer or presenting that risk was enough
Right,
to
but that
sustain the
seems to
conviction.
me that is more analogous to Lyons than it is to this case. That is, as Justice Cowan was saying, I mean, the officer is right there next to the defendant. The risk is immediate. He's not injured, not because of anything that he decided to do. As I say, it seems much more analogous to the person in the water with the struggling defendant who goes limp. No, those officers weren't hurt, but the risk was immediate and real.
Well, I think the risk was immediate and real here. There was very poor lighting. There was evidence of that. The officer was only 10 yards away in full flight. He did manage to stop, but the risk was still there.
Isn't there some evidence that they decided to stop, and they looked over and they said, and then they got somebody to go get the ladder down?
Right, but
I mean,
the
it wasn't
danger was
like they
there.
just, that they were stopped by the fence. I mean, they made a decision. We're not doing that.
They did have enough time to stop, make the decision not to go in after him.
But see, if we follow your theory, it seems to me that there would be a substantial risk here, because the police, what if they didn't know that the water was at the bottom and they just went over the same way the defendant did? There's still a substantial risk to them.
The risk is the same whether they go over or not, and I think by focusing on the risk and not the bodily injury itself, the legislators sought to safeguard police from those dangerous situations.
Isn't the core issue here is that you are saying that one measures the risk of bodily injury at the time of the conduct of the defendant, and Mr. Abogado was saying, no, you measure the risk of bodily injury after the fact.
Right. I think the risk has to be assessed at the time. It has to take in the account of where the actors are. If the police were 50 yards or 100 yards back, the risk may not be, well, it is not as great, but it is still present considering the lighting conditions, the damaged fence, which I have a photo on page 3 of my appendix. And I think from the photo, it is evident that there was a risk here.
Okay, so going to my rooftop tenement flight, which avoids all the issues of the crime surrounding flight from a police officer on the roadway. If I'm jumping over that roof as a suspect, you're saying at that moment in time, knowing that they're going to flee, knowing that they're in pursuit of me, I've created a bodily risk that I know when I cross over that if they pursue it, they're going to be at risk, which is why I'm doing it.
Right, and there has to be an arrest. I mean, the police have committed.
Right.
Just as danger invites.
Let's assume we've got
Right.
that prong, which here is conceded, that the person knows he's under arrest. You're saying that at the very moment that I, as the suspect, leap over that rooftop to the other tenement rooftop, that at that point in time we measure what is the risk of bodily injury to the pursuing police officer.
Right, just as danger invites rescue, flight invites pursuit, especially when the police are trying to execute their duty.
Isn't the way out of this, Mr. Townsend, is to focus on Justice Spina's question, which is that it's the knowingly preventing the arrest. If you engage in conduct that if the police pursue you and stop you and catch you, that's one way to do it. You may get injured along the way. You know, they catch you, they take a flying leap at you, and they drag you down, and they catch you. The other is you're doing something, putting them at risk for the purpose of knowingly preventing an arrest. And isn't that your argument, that you have to link it back to 32B-A?
Well, I think A is separate. I think we have to link it back to the conduct
No,
portion of the statute.
but I
which
understand.
comes
But
before.
where you don't effectuate an arrest, the statute is broad enough to say you knowingly prevent an arrest. The way you are preventing the arrest in this case is by creating circumstances that have a substantial risk of bodily harm if the arrest occurs.
While they're effecting the arrest. I think that is right.
Well, they can't effect the arrest because they're not going to get into the dangerous situation. So by creating the circumstance where if they pursue you, the defendant, they will get into a dangerous circumstance, the defendant has acted in a way that knowingly prevents the effectuation of the release.
I agree with that.
So you link it back to the A, where there's a withdrawal, a stop, or something else because of the danger.
Well, I think I link it back, if my reading of the statute is correct, yes, to the A, not to the 1. I mistook,
Yes.
Your Honor. I thought you were referring to 1. I do link it back to the A.
Yes.
So there has to be conduct by the defendant, knowing the police are under color of law, they're seeking to make an arrest. If the elements for a seizure and arrest are met, and he continues that conduct by any other means with a substantial risk to create bodily injury, yes, I think the circumstances of those scenarios.
But it's so that if the police officers do not accept the risk, then he has, in the words of the
Knowingly-
statute, prevented them.
Knowingly prevented.
He knowingly prevented them from effecting an arrest. If the police officers do accept the risk and continue the pursuit, then it is an attempt to prevent the arrest. It just didn't work.
I agree with that.
The creation of the risk didn't work.
Or has Oh, no, you have,
It was an attempt to prevent, and
yeah,
so
because
they
you
were,
don't, you have an arrest.
yeah, you have it.
Right, and I think B, or number 2, is intentionally broader than number 1. Number 1 is focusing on violence, use of force, threats of violence. If the defendant had turned around and
No,
aimed the gun...
I'm only focusing on the withdrawal scenario. I'm only focusing on the withdrawal
I think
scenario.
he has attempted at that point to prevent the arrest.
Knowingly prevent. Yeah.
Right, by exposing the officer to the risk. That the officer did not accept the risk and dive into the canal should not be relevant to the determination that he
Does it
attempted to
matter
resist
in
arrest.
these, accepting for the moment that the defendant had no idea that he was going into the canal, okay? Does it I mean, do you have to worry about whether he knowingly was using means to create a risk?
I think that knowingly attaches to Section A. I think to some extent...
Yes, but it's
it does,
knowingly
it does, it does.
preventing by using. So don't we have to start worrying about whether he knowingly was using this means to prevent the arrest?
I think he has to knowingly try to prevent the police from making an arrest.
By this means?
I think the means is more objective. I think
Says
his
by
intent
using
has
any-
some bearing on it. The defendant's testimony would not be in the light most favorable to the Commonwealth. He was jumping into the canal to dispose of the gun, in our view. So I think he knew, and he was familiar with the neighborhood. He knew what was there, and that's why he ran to the canal.
At least I assume that if you see a fence and it's dark, and I assume the evidence is it was dark,
Yes, it was.
and you can't see what's on the other side, and you jump over the fence,
That's a risky behavior.
That's
You've
pretty
got
risky
someone
behavior.
trailing right behind you.
yeah.
Unless there's further inquiry from the court, the rest of my brief.
Thank you, Mr.
Thank you.
Townsend.